Let's resume the clause-by-clause scrutiny of the bill. Ms. Zhang, please carry on. Thank you, Chairman. Next, the new subdivision for recovery of costs, etc. for carrying out of fire safety improvement works by enforcement authorities, etc. That's on page C1953 and page 36 of the marked up copy. That is the relevant mechanism. We have drawn reference from the experience of carrying out the further works of the BD and the Buildings Ordinance. In order to allow members to understand the mechanism of the recovery of costs and surcharges, I will brief members on Section 19T all the way to Section 19W. Section 19T, brackets 1, 2, 3, the enforcement authorities will recover costs and surcharges in relation to fire safety improvement works and other works, such as construction material costs. There will be a surcharge of not more than 25%. We will take into account the share of ownership of the property owner in order to calculate the costs that the owners need to pay. We will use different rates to calculate the costs involved. Having added up all the costs, they will issue a payment notice to owners, listing out the fees that they have to pay. There will also be a deadline before which owners need to pay the fees. Owners who do not pay the fees on time, in accordance with Section 19U, brackets 1, brackets 2, they will be issued with a recovery notice. There will be an interest rate of 10% on the part of the fees not paid. (19V) brackets 1 brackets 2 under Section 19V registration of certificates, it aims at protecting the interests of the government. They allow the costs to be fully recovered from the owners in relation to the service of writs. It will be covered under Section 19W in relation to the service of writ of summons. One month afterwards, if the property owner still does not pay the relevant fees, the DOJ will refer the case to, for example, the Lands Tribunal for the recovery of the fees. If the property owner has already paid all the payments required, in accordance with Section 19V, bracket 6 and bracket 8, the certificate will be deemed not in force. It is in relation to the recovery mechanism of the relevant fees. Well, please pause right here. Mr. Kong. Thank you, Chairman. I'd like to ask about Section 19T, 2G. As I understand, you have drawn reference from Section 33, brackets 2 of the Buildings Ordinance. In Section 33, brackets 2, there seems to be no subsection G. What does it cover? I mean, what fees does it cover? Pardon me. is a catch-all provision just to complete the legislation. I understand it's a catch-all provision, but members of the public worry that they may be caught by the law as well. Members of the public are of the view that Section 33, Brackets 2 contain very reasonable fees. What does other costs mean? From A to F, in theory, they already include a lot of matters. A, the costs of carrying out the fire safety improvement works concern. It covers a lot of the costs. In relation to supervisory charges, interest, all these have been listed. For G, under Section 33, Brackets 2 of the Buildings Ordinance, there is no such catch-all provision in the Buildings Ordinance. Why do we need to have such a provision under Cap 572? Any follow-up? PS? Thank you, Chairman. Thank you, Member, for your question. In dealing with construction wastes, the Environmental Protection Department has costs, and we collect these costs based on the principle of users pay. I need to emphasize we are helping members of the public. We discuss with them the amount or the fees to be collected. In case of any disputes or arguments, when there is disagreement on the part of the landowners or the property owners, professionals, stakeholders will provide opinions to the authority. That is to ensure transparency. So we want to communicate the messages clearly. Legal Advisor Ms. Chan. Thank you, Chairman. The following question is about Subdivision 4. That is the recovery of costs for carrying out fire safety improvement works. Is there any appeal mechanism for those who need to lodge an appeal in relation to the breakdown of the fees? Earlier on, in the LSD's letter, point number 8, it was already mentioned. The administration replied that they have drawn reference from the buildings department. In fact, they already have such an administrative mechanism. So, they do not think they need to set down provisions about an appeal mechanism. I'd like to hear from the administration. Is there any follow-up or supplementary information about the administrative appeal mechanism? PS. Thank you, Chairman. Thank you, Legal Advisor. Our project is aimed at helping members of the public. We are not imposing a burden on members of the public. We don't think we need a special mechanism, so to speak. However, if there are different proposals or views of members of the public, they can submit their views to the committee. These projects are open, they are transparent. These are not very complicated works. There will be a price model so the members of the public can judge whether the fees are reasonable. Any views? Any sharing? The buildings department carry out defaulted works. Afterwards, the costs will be borne, or they will be shared. A letter and a bill will be sent to the users. informing them of the fees to be paid. The bill will also contain a breakdown, for example, surcharges, supervisory charges. There are breakdown fees. In our letter, it also sets out that owners can contact us in case of any questions. The relevant owners said that there is no appeal mechanism, but then they would reach out to the buildings department and we will explain the situation to them. When they have understood, there will not be any concerns. Thank you.
Mr. Kwok Wai Kan. Thank you, Chairman. I agree that the government is trying to help the people. Things are even more difficult for buildings without owners' cooperation. But apart from the cost of the works, which should be transparent, but I want to ask about the supervisory charges. Is there a formula on the calculation of such supervisory charge within the government? The people don't really know about how the supervisory charge would be calculated. When will the owners be made aware of the level of the supervisory charge? Because, well, will the government tell the owners the charge prior to the start of the works? Owners don't want any surprise. They want to know what the charge is prior to the start of the works. So I want to ask when the owners would be made aware of the level of the supervisory charge. Permanent Secretary, I'll ask Ms. Chung or Mr. Ng to explain about the actual operation of the provision. Thank you. Let me talk about the structure of defaulted works. We make use of a fixed contract for engaging the contractors. We don't tender for each of the buildings. We use a term contract. We, through the stores and procurement regulations, invite for tender after selecting the consultant and contractors. And then we will assess the tenders of the consultants and contractors, and we look at also their experience. We follow the regulations. After the consultant and contractors won the tender, we may assign a certain district to a consultant within the, for example, 2 years contract. So within the 2-year contract, the works in that particular district will be done by the consultant that's been awarded the tender. The supervisory charge will be charged at a percentage of the total cost of the works. If the cost of the defaulted works is low, then the supervisory charge would be low as well. The people would not know how much the supervisory charge costs before the completion of the works. But when we issue the payment notice to the owners, we'll set out the breakdown so that owners know how much the supervisory charge is. And that's the mechanism of the buildings department. Now in the future, the enforcement authority will look at and monitor the works. We don't just assign the defaulted works to the consultant. When we select the building, we ask the consultant to submit a plan for the EA for approval. When the plan is reasonable and approved, the contractors will come in and start the works. So we will only be able to know how much the defaulted works cost when it's completed. But there will be a preliminary calculation under the operation building Bright. The consultant would give us an estimate of the cost of the defaulted works, and after that we can tell the owners about the estimates of the works. but the estimated cost may not be the final cost of the works. So it seems that the supervisory charge is charged at a percentage of the total cost, but I wonder what the percentage is. Is it different among different contractors or consultants? Every penny matters. If the charge is charged at a percentage of the defaulted works, then the owners will only know how much they have to pay in terms of supervisory charge when the works is completed. So can you give us the range of the percentage for the supervisory charge? Thank you. Ms. Ng? Now, we have not drafted any contracts in relation to the Fire Safety Buildings Amendment Bill, so I cannot really tell you about the percentage as of right now. We make reference to the information on the URA's portal when we formulate the contract. When we invite for tender, we look at the price of the tenderers, and we make reference to a lot of different information of the URA when we assess the reasonableness of the price. We look at the contracts awarded by the URA on fire safety, for example. For buildings department, we remove unauthorized building works, and sometimes we charge the supervisory charge at 5% or to 10% of the total cost. Next, Ms. Doreen Kong. Thank you. I would like to ask about 19V bracket 7. It is said that if after the completion of the fire safety improvement work specified in the recovery certificate, but before the registration of the certificate, a person has acquired and registered an interest in the building concerned as a bona fide purchaser for valuable consideration. I know that you registered the direction with the land registry, but according to 14B, owners have to notify the authorities when they acquire a building or acquire a flat. So when will bracket 7 under 19V be invoked? Provisions such as 14B is not present in the buildings ordinance. So new owners must be aware of the direction or order against a particular building. I'll ask Mr. Fong to explain about that. Thank you for the question. Regarding 19V bracket 7, when we issue a demand note to the owners to recover the cost, and if the owner defaults on the fees, then we'll issue a certificate of recovery. We will register that against the building in the lands registry. After that, the owners would know how much the old owner is owing the government. We can recover the cost from the new owners. However, in the contract, in the charge, we cannot really see how much the cost is outstanding, and we have to protect the new owners. Then what is the use of Section 14B? What do you mean by genuine buyers? After the buyer's been made aware of the order or direction, they have to notify the enforcement authorities. The charge could be registered in a few months' time. This I want to clarify. So even if I'm aware of the order or direction, as long as I register it against the building in the land registry earlier than the issuance of recovery certificate, then I will enjoy a priority. Is that right? Well, for 14B, we don't. Well, it doesn't just cover defaulted works, because sometimes after issuance of order or direction, the flat's been sold to another person, and in theory, the new owners would have to shoulder the legal responsibility. That is why under 14B, we ask the new buyers to notify the EA of the transfer of interests. As for 19V bracket 7, we're talking about defaulted payment. Under such circumstances, we would have issued a demand note to the old owners. And when a buyer comes in, the charge does not reflect in the land registry, then we should rectify it. And we should show the demand note in the land registry. We have made reference to the buildings ordinance, and that's why we add the words genuine buyer here to make sure that the buyers is aware of the demand note in place against the flat. Next, Mr. Andrew Lam. I want to ask about 19U bracket IV. Also 19V bracket 7. Sorry, bracket 5. Now 19U. For the purpose of this subdivision, the relevant enforcement authority may issue a certificate specifying the payment of any cost or surcharge. Unless there is only one such person, and apportionment of the payment among the persons that the authority considers appropriate. Will apportionment be happening when the fee is not controversial? Second, if at first possession is involved, who should be responsible? And how will you apportion the cost in that case? My last question. Will more than one authorities be issuing direction? That's my first question. Permanent Secretary. Thank you. Thank you, Mr. Lam, for the question regarding to the apportionment. We apportion the cost based on the shares of the ownership. We're talking about common parts under 19U. So the example about adverse possession will not be applicable. fire safety improvement works involve 2 different departments, but we only have 1 case manager following up each case. Fire safety improvement works may involve installation of windows by the buildings department or the installation of hose and reels by the fire safety or fire services department. But we only have 1 case manager for each case. It could be a colleague from the FSD or the BD. Mr. Lam. One question has not been answered. When there is controversy regarding the apportionment, will the authority's decision be final? Is there any ways for people to dispute the cost? Well, the EA will be the decision maker in this case, but that's of course subject to judicial review. Permanent Secretary, you said that you base the apportionment on undivided shares, but some buildings don't have undivided shares. How will you apportion the cost in that case? What about unauthorized building works that are generated from adverse possession? Perhaps I'll ask Ms. Ng to talk about the actual operation. Thank you, Chairman. Of course, each owners will have to be responsible for their own shares. For common parts under DMC, all owners will be responsible for maintaining it. We base the apportionment on the shares of ownership. As for the question about adverse possession, if the unauthorized building works is on the roof and that roof is a common part of the building, then we will apportion the cost of removal of the unauthorized building works among all owners. However, if the unauthorized building works is constructed or erected by a particular owner, then we will only recover the cost from that particular owner. Regarding adverse possession, we look at the land registry to check who the owner is before we recover the cost. Their answers still assumes that all buildings have a DMC and undivided shares. Under 19, all buildings are covered. What about buildings without DMC and undivided shares? How will you apportion the cost in that case? For some old buildings, they don't have DMC. How will you deal with that?
We haven't come across such a case without undivided shares. For old leases, in such cases, we haven't come across a situation where defaulted works are required. We haven't come across any property without undivided shares. We really haven't come across this case. Right, but it doesn't mean that this won't happen, because in reality, we have a lot of buildings without DMCs. I'd say this is a loophole. I asked whether you have absolute authority over this. If you have absolute authority over how apportionment should be made, then it's not for anyone to dispute that. But at the moment, you don't have a set of criteria for apportionment of payment in relation to buildings without DMCs. So please think carefully again before you answer. Right, 2 questions. First, have you considered the apportionment criteria? Second, is it within your authority to decide on apportionment matters? Of course, the avenue of judicial review is always available, but it's a rarity, and not often would anyone be able to win a case of judicial review. In reality, if we run into problems with land titles and apportionment matters, we will seek legal advice. For example, we have had issues with apportionment of costs of repairing, say, the exterior of buildings, and we seek legal advice in such circumstances. After we issue a demand note, an aggrieved owner who would like to raise objection will approach us. I'm sorry, I can't accept this answer because we are discussing this bill which has yet to be passed. I don't want to wait until you run into problems. There are many old buildings without DMCs, without undivided shares. I fully agree with Chairman that there should be a set of criteria in order to ward off judicial reviews or judicial challenges. You can't wait until cases come up. You should go back and think about it. I think you explained your approach. If you could devise a set of criteria, there will be consistency. There won't be differential treatment of different cases. Right, I think we'll go back and prepare a supplementary answer on the issue of criteria. Let me move on to the second question. 19B bracket 5. A specified payment is not recoverable from a person to the extent that the amount of the specified payment concerned exceeds the value of the person's interest in the building concerned. In other words, if it goes beyond the value of the person's interest in the building, you can't recover the payment. My question is this: how and when and by whom is the value determined? Because are we talking about the market rate? If there is no transaction of that property at all, you can't determine the value. How do you determine whether the payment exceeds the value or not? You need valuation of the person's interest in full or in part, and that means you need to rely on market transaction data. Otherwise, valuation won't work. Right, how do you determine the value here? Listen, have you come across anything like that? Under the buildings ordinance, we haven't come across the situation you mentioned. Well, we discussed in recovering payment whether the property will have to be sold, and only when such a circumstance arises will we have to determine the value in such a way. And we haven't come across that. By value here, are you referring to the market value? When you take action to recover the payment, do you peg the payment to market rates? I think there should be clarity. We need to determine the market value for recovery of payment. But I think that this situation has not arisen because we're talking about common parts of the building with apportionment of payment among many owners. So the chance of the specified payment exceeding the value of the person's interest in the building will be quite slim. Anything from the legal advisor? Right, on 19V5, as put by the member, on determination of the value of the person's interests, I will invite members to go to 3A of 19V in relation to recovering the payment by action in court. So it's about the legal proceedings as mentioned here. I stand to be corrected, but when it comes to recovery action in court, experts will have to be, or expert witnesses will have to be called to testify on the value of the property. So we need evidence from the expert witness to determine the value of the interest of the property. We need expert evidence from both parties. So let's hear from the administration as to whether my understanding is correct. Chairman, may I step in here before you allow the administration to reply to the legal advisor? Permanent Secretary, you may recall that when we started off discussing policy issues at the Bills Committee, I asked the government about the procedures of recovering the payment. I think I got an answer from the Permanent Secretary I was quite happy with. I didn't ask any follow-up question. I've waited until now. With the passage of the bill, the penalties will be increased. As far as I know, and as far as what I've heard, the administration has never recovered payment from any owner. You talked about imposing encumbrances or registering a charge against the land title, but that doesn't have any teeth. There's no clout. In other words, in order to recover the payments, you need to go through the Department of Justice and go through the legal proceedings. I thank the legal advisor for supplementing their answer. I really want the administration to explain the relevant procedures. You can't just register the charge against the land title. You need to take action to recover the payment. Let me tell you from our experience, the recovery rate is really high. According to Operation Building Bright 2.0, we had 1,400 cases, and in 88% of these cases, we were able to recover the payments. And 65% among the 88% of recovery cases, we were able to recover the payments even before we had issued the demand notes. For 23% of the cases, we recovered the payments before we registered the instrument against the land title. And for the rest, we proceeded to taking action, because I fully agree with the legal advisor that, of course, we should recover the payment that we are entitled to. We don't want to sell the properties because it's not our intention. Let me tell you once again that we're not talking about an astronomical sum. For a 13-story building, the total project cost was just $2.1 million. So after apportionment, we're talking about some $10,000 per household. What's more is that we allow payment by installment by up to 60 months. So that means an owner is required to pay only some $200 a month. Of course, if there is payment in arrears, we will go by the legal avenue and recover the payment. I will now give the floor to my colleague to elaborate on the written reply. Ms. Zhang, thank you, member, for the question and comment on recovering the cost of works. CB bracket 2 1145/2024 bracket 06. In this paper, we already gave a reply, and also we responded to the legal advisor's questions. We explained the procedures involved, and let me go through them again. First, upon completion of works, the enforcement authorities will ascertain with a consultant, and then, according to the undivided shares, we will start the recovery action. Owners will be able to give evidence as to whether they deserve a waiver of the charge, and then altogether we do calculations and issue the demand note within 14 days. The owner concerned will be required to pay up, and if the owner fails to do so within the time frame specified, then according to the provision here, the certificate will be issued, and within 30 days, if the owner is unable to pay up as per the recovery certificates, or if the owner doesn't make full payment, then we will impose an interest of 10% on the amount, and then we'll also register the charge against the land title. But once the owner has paid up, a certificate will be issued to certify that the owner has made the payment in full, and then this instrument will be registered in the land register as well. Mr. Lam is also concerned about registering the instruments in the land register and whether there is a time frame for recovering payment. Permanent Secretary, I thank you for the explanation. I read the paper as well, but we're talking about the 12% of owners who failed to respond to your request. What's the procedures that followed? Right, the land register is not the end of the matter. Well, once we've completed this step, the buildings department does have experience in carrying out defaulted works, and we're going to refer the cases to the relevant departments to take legal action. For example, the Department of Justice will consider whether to file a claim with the Small Claims Tribunal. On a half-yearly basis, we update our database and review these cases. After referring the cases to the Department of Justice, we still need to wait for the hearing to take place. And the Department of Justice may also ask for an update, because the Department of Justice may issue a summons or serve a summons on the owner to no avail. There are resource implications, but we do update and review the case data on a half-yearly basis. I know that two members would like to ask more questions. I'm sorry to say that we've been spending quite some time on the same question already. So let's hear from the Department of Justice and see whether he could supplement the answer. Mr. Y? On recovery of payment, perhaps I will talk to the Civil Division of my department and give you a supplementary answer later. Next, Ms. Carmen Kan. Thank you, Chair. Still on the same topic, and that is about apportionment of liabilities. About 14 capital B, that is the new owner is required to notify the enforcement authorities of transfer of interest. My first question is whether the same provision exists in the Buildings Ordinance. No, it doesn't. This is the actual experience as we carry out fire safety improvement works. After conveyance of property, new owners may not own up to their responsibility. It takes some time for them to do so. So we want to provide legal safeguards here, and is a basket of tools that we have devised. Ms. Carmen Can. So that's a very important difference here. As mentioned by Ms. Doreen Kong in 14 capital B, and I'm sure Ms. Doreen Kong is familiar with conveyancing matters. The new owner must know about the fire safety directions or orders. Under the proposed defaulted works mechanism, the fire safety compliance orders as well as the fire safety directions will have been registered in the land register. So it must come to the attention of the new owner. You said you've made reference to the Buildings Ordinance, but this provision is an exception. This doesn't exist in the Buildings Ordinance. So when you copy 19V from the Buildings Ordinance, there could be a confusion here. There are a number of provisions, bracket 3 in 19V, when Mr. Lam just now referred to this bit, subject to subsection 5 or subsection 7, whether a legal charge will be imposed, as well as bracket 7, there is an exception, and that the bona fide purchaser is absolved from its liability. But in reality, this purchaser could never be a bona fide purchaser, because according to your explanation, as long as this purchaser is ignorant about the demand notice or recovery certificate, then this purchaser can still be regarded as bona fide. But now, according to subsection 7, now as long as this new owner knows about the fire safety directions and has notified the enforcement authorities about the transfer of interest, then this purchaser will be absolved from his liability, and that the government will just go after the old owner. But then the original owner does not own the property anymore. It becomes a new civil debt. And then subsection 8 provides that if the payment is not made, then this charge will not be removed from the land registry. So in other words, the new owner will be held hostage to fortune until the old owner pays up. Well, that's because of the inconsistency with the Buildings Ordinance, as 14B doesn't exist in the Buildings Ordinance. Permanent Secretary, can you explain the point and see if Carmen Can's understanding is correct? Thank you, Ms. Can, for the question. As I explained just now, for 14B, after transfer of interest, we will require the new owner to notify us so that a new direction will be issued against the new owner. The difference between this and 19V bracket 7 is that for bracket 7, it refers to payment in arrears, and that a recovery certificate has been issued to the original owner, and before imposing an encumbrance, in fact, according to the legal advice we receive at the time of conveyancing, the new purchaser knows about the fire safety direction, but it doesn't mean that the owner must know that the original owner will be defaulting payment. So at the time of transaction, only when the new owner is aware of the payment in default will the owner be held liable. So like Ms. Carmen Khan said, perhaps even before we register this recovery certificate, the new owner could still be regarded as a bona fide purchaser. In order to protect the government's interests, we make sure that when a new owner takes over this property, and if this new owner is aware of the payment in default, then we can go after the new owner.
想補充嗎？
Legal advisor, any follow-up? No. Ms. Carmen Khan? We've heard about the procedures, and I don't think this is the ordinary conveyancing procedure. Probably Mr. Kong can supplement in a moment. You mentioned you could hold the new property buyer accountable, and that is in relation to subsection 7 and 8. And that is just an ordinary civil matter. And the lawyer will not help either. In conveyancing procedures, is it possible to, for example, hold a sum of money, and during the conveyancing procedures this will be dealt with, instead of having a lot of disclaimers in the bill? So recovery would not be useful. In the BO, there is no 14 capital letter B, so the buyer will not be informed of this. The intermediary will not help the new buyer either. When we add this to the bill, do we not need to do a lot of copying and pasting? Thank you, Chairman. Thank you, Member. These are two matters. For 14 capital letter B, that is the responsibility on the part of the new property buyer. And we are talking about the recovery of payments. When the new property buyer does not know there is such a payment in arrears, that is reasonable. Mr. Kong? Chairman, I'll be quick. I thank Ms. Carmen Khan for asking this question very clearly. I believe the administration will have to go back and take a look at it. Section 14, capital letter B, and Section 19V, subsection 7. These two are related, and I believe they have a bearing on each other. Under Section 14B, when a buyer needs to inform you, it means the buyer already knows there is a contingent liability. He or she may not have to know the exact fee. When they know there is such a contingent liability, that is not a bona fide buyer already. I'm not asking for actual liability. I'm talking about contingent liability. Section 19V bracket 7, should we put it this way? I mean, should we draft it this way? Just now, Mr. Andrew Lam mentioned the point of apportionment. Under this bill, you invoke Section 19L brackets 1-4 as long as you deem it appropriate. It's all right. You mentioned we factor in the DMC, the shares. I want to talk about examples, not adverse possession. This may be close to the heart of the general public. For example, in relation to fire safety improvement works, there may be obstruction of the means of escape. Some may close the gates, and that has to do with a common part of the building. It may not be an extension of the private area, and that is probably just an extension into the common area. What about the obstruction of the means of escape? What about the obstruction in rear stairs? It's a common part, and it may not be just one's own possessions. In North Point, one occupies the lift of another. One occupies the rear staircase, which is not one's own building. They use it to convey goods. You really have to pursue the individual owners according to apportionment. Is that the case? You said you will provide us with the criteria of apportionment. P.S. Any follow-up? Yes, we'll supplement you with the criteria later on. Regarding Mr. Kong's point, obstruction at the fire door or the means of escape, this will be dealt with under Cap 95, that is the Fire Services Ordinance. That would give rise to criminal liabilities. We have not just Cap 572, we also have an array of ordinances to deal with different situations. Mr. Andrew Lam. Thank you, Chairman. I'd like to write on the points mentioned by the two members, as well as the reply given by the PS. Section 14, capital letter B, targets new buyers. Section 19 targets recovery of payments. On the determination of the value, whose responsibility? If I want to invoke Section 14b, there's a new buyer. When the legal structure, the removal of the legal structure would cause one to owe the government $1 million, and when one buys the structure at $800,000, when one wants to pursue the amount, one pursues the original property owner instead of the buyer of the property. Is that correct? P.S. Please speak into the microphone. Thank you, member, for your question. What I mentioned is that at the time of the purchase of the property, the liability of the payment in arrears is not registered with the property. The buyer does not know the payment in arrears. However, when one does a land search with the land registry, one already has told the buyer about this. Then the responsibility rests with the buyer. In relation to the shares of the flat or the price of the flat, the legal advisor has already said that one would have to engage a professional to go through all the procedures. When one owes you $1 million, for instance, before registration, if one sells the property at $800,000, is this scenario possible? If yes, the new buyer would not be held accountable. In accordance with Section 19, before registration, how are you going to determine the value? The selling price is only $800,000. There is a bona fide buyer. That buyer indeed buys the property? Well, you don't have to give me an answer right now. I want you to go back to take a look at it. In our conversations, I think that you have not thought it through. But of course, if you're confident right now, I want to hear an answer from you. But I want you to think carefully about this. P.S. Any follow-up? Thank you, Mr. Andrew Lam. We can tell you more about Section 18B and Section 19V. If the direction or order is still in force, when a new property buyer buys a new flat, one will have to comply with the direction. If the requirement is not met under Cap 572, that is the prerequisite. Under Section 19, when the government steps in and finishes the defaulted works, after the communication between the enforcement authorities and the contractors, that's the procedure for recovery. In other words, Section 19V is that the fire safety direction or the compliance order has already been complied with to the satisfaction according to Cap 572. So Section 19V and Section 14B are different in nature. I hope I have answered your question. Ms. Andrew Lam. In Section 19V, after defaulted works, there is no encumbrance imposed yet. You won't impose an encumbrance right away. When one sells the flat at $800,000, let me pause right here. What is the responsibility on the part of the new property buyer? Ms. Zhang or PS, who is going to take this question? For the demand note, it has not been registered yet. So the person being pursued is still the original property buyer. If the price is still the market value, will it be below the amount owed? So you can only pursue the amount at which the property is sold. That is below $1 million. Is that correct? Yes, that is correct, but this would not happen in a construction project under Cap 572. A building might cost only $2 million or so. To each individual owner, it may be about $10,000 or so. Let's just assume this situation will not arise, given the fact that there is apportionment. What about single block building? The amount will not be that small. So the incentives will be different on different occasions. Fire safety is important. It's okay if the government, even if the government receives less, because fire safety is crucial. Well, it's possible that in subsequent provisions you can plug the gap or you can plug the loophole. But we need to think very carefully about the criteria. For single block buildings, that is not within the scope of million-dollar projects. Just now the legal advisor said, be it the unit or the property, if I understand correctly, the value is the market value. And the market value is to be determined by a professional. If the market value is below the amount that needs to be recovered in the past. There weren't such cases, and in the future there won't be such cases either, in my opinion. The amount being pursued is not that significant. Mr. Y. Thank you, Chairman. Thank you, Member, for your question. Just now, Mr. Andrew Lam referred to the situation. Let's just assume at the outset, at the completion of a project in accordance with Section 19T, brackets 1A, the owner, that is the original owner, has the legal liability to pay the relevant fee. And that is a different matter with the demand note under Section 19V. If the cost is not recovered in its entirety, the authority can issue this recovery notice. In the land registry, the property owner has legal liabilities in relation to the recovery certificate. Regarding the question about market value, there is a limit in the recovery certificate, but there is no such in the responsibility under Section 19T. Well, Chairman, I don't understand at all. You mentioned under Section 19T, when one does not pay, or when one does not pay in full, you would invoke Section 19V to recover the fees. To put it bluntly, when one sells the property to save money and when they agree on a price in advance, the actual selling price would become the market price. In accordance with Section 19V, you can only recover the market value. Is that the real value? Whatever the discount, one would have saved 20% to 30% probably. The PS said the chance is very slim. If that's your answer, then it's your answer. But I don't understand the reply given by the officer just now. Section 19V, one can simply come up with a value and you would not be able to recover the value. Well, if they agree on a price in advance, are they still bona fide buyers? Section 19T about the amount of the costs. The cost is is just the cost of the construction project. Section 19V, how can we recover the cost of the government? What Mr. Andrew Lam mentioned is actually a criminal liability, that is price fixing. If, for example, the property is sold at just thousands of dollars, is that a case of fraud? Is that deception? We'll see what criminal ordinances we can invoke. Of course, that is a hypothetical question, but is the chance slim? Next, Mr. Ring Kong, thank you.
我想幫大家
Thank you, Chairman. I want to clarify one point. Some members ask if 19v7 happens, that is, if a bona fide buyers are not aware of the demand note, then we cannot recover the cost from that buyer. Are we able to recover the cost from the original owner? I want to clarify one point. According to 19T1A, we cannot recover the cost from the original owner. That's the loophole. Because under 19T1A, it is said that if the relevant fire safety direction is registered, then that would constitute a civil debt. And the person who is the owner of the building on the date on which the works are completed will have to pay the civil or repay the civil debt. We often refer to a bona fide buyer, but then under this case, no one would be held liable. Under this section, we can only recover the cost from the owners upon completion. Thank you. Thank you, Ms. Khan. Under 19T bracket 1, it is set out whom we can recover the cost from. If the works are completed, then we will recover the cost from the owners listed on the land registry. But according to 19V bracket 7, well, actually the entire section 19V is about the protection of the rights of the government. We also have to protect the buyers who are not aware of the outstanding payment. Only after the recovery certificate has been registered at the land registry will the buyers be made aware of the outstanding payment. Maybe after the buyer's been made aware of the outstanding payment, they will negotiate with the original owner about the price. The reason why we refer to a bona fide buyer is because new buyers are not aware of the outstanding payment if the recovery certificate is not registered. And when the lawyers of the buyer conduct the land search, they may not be aware of the outstanding payment situation. That's why we have to protect them by stating that we will not recover the cost from this kind of buyer. Ms. Carmen Khan. I have a suggestion. Maybe the administration should look at the two sections that are 14B and the 19V, because the responsibilities set out in 14B are not present in the building ordinance. Maybe the administration can consult professionals who are engaged in property transactions to learn about the actual situations. Because we have this 14B, we cannot prove whether a buyer is a bona fide buyer. For 19V bracket 8, well, I will have to wait until the full recovery of the payment before the recovery certificate is being discharged from the land registry. With the new 14B, there are other problems in relation to the apportionment of the ownership of shares. Can you go back and think about that? Because we've been scrutinizing these two sections for quite some time. Permanent Secretary, yes. Dr. Lo Wai Kok. Having been through the discussion, we have given a lot of hypothetical scenarios. We just want to see or know under what circumstances would the new buyers be liable or be responsible to pay the payment. If it can be confirmed, well, if you can state very clearly under what circumstances would the original buyer will have to, original owner have to bear the cost, and under what circumstances would the new buyer have to bear the cost, that would be very clear. If the works cost more than the price of the property, then the government should think twice before carrying out the works. That is completely correct. That's what we're trying to explain. Please explain in writing after the meeting. Maybe you can use a flow chart to illustrate the points. Say, under what circumstances would the new buyer have to pay the cost, and under what circumstances would the original buyer have to pay? I know that you're confident that there will not be any controversy, but I hope that you will explain it very clearly in a document or in writing. Permanent Secretary. What Dr. Low said was completely correct. We are not worried that the hypothetical situation will happen. Perhaps we will make use of a flow chart to better illustrate our points. Mr. Andrew Lam. Is it possible for the government to not be able to recover the cost from either the new and old owners? That's possible. Well, regarding the penalty, that is $25,000 plus daily fine. In reality, some owners just don't pay the fees and penalty. I've calculated the case for you for some $15,000 plus daily fine. If the owner violates the ordinance for a long time, then the total penalty would be very heavy. The provisions are here to be invoked. And there's been cases where some senior owners simply ignore your direction or order. Usually, the magistrates hands down a very light penalty. If the administration is actually enforcing the provisions, then the total fine could be very substantial. Unless we're telling the people that the provisions are not going to be enforced. Now, going back to Ms. Khan's suggestion, I hope that you will think about the issues that we've raised today. I believe that most citizens in Hong Kong are law-abiding. The chance of the hypothetical situations happening is very slim, but if one of such scenario actually realizes, then it would be very serious. Permanent Secretary, I have nothing to add. Then please proceed. Ms. Cheung. Now we've come to clause 19, that is C1967 of the Blue Bill, and page 43 of the marked up copy. We are going to add a heading before section 20, division 1. government's liability to make the principal legislation clearer. Clause 20 and 21, they are technical amendments. Under Section 20 and 21, we repeal the reference of government and replace it with Hong Kong SAR government. That's according to Cap 1. We want to maintain consistency. Now, we've come to Clause 23, that is C1969. We'll add a heading before Section 22. That's to improve the structure of the ordinance. Now we've come to Clause 23 of the bill that cover 2 sections. Now let me first talk about Section 22. That is offenses by body corporate and partnership. In Section 17, we have repealed, or in Clause 17, we've repealed Section 19 that stipulates offenses by members of the body corporate. The reason why we repeal that is because we will add the elements here instead. Under, the structure of Section 22A is similar to the drafting of the CAP 636 Fire Safety Industrial Buildings Ordinance. The drafting is the same as Section 19. Please pause here. Ms. Doreen Kong. Thank you. I'd like to ask about 23C. For non-body corporates that are individuals, I have some questions. A lot of people rent out their flats. If you only serve the document on the occupiers, that could be the tenants instead of the owners. How can we protect the owners? If the document is served on the tenants, then the tenants may not deliver the document to the owners. Regarding service on non-bodied corporate, as you can see, there are different ways of delivery. When we are trying to recover the cost, sometimes we cannot identify the owners. With such a section, there will be ways for us to reach out to the owners. Maybe we can contact, for example, the authorized person or representative. It's the owner's responsibility to maintain their buildings, and the owners have a responsibility to share with us their contact means. We want to encourage the owners to leave their means of contact with the EA so that we can reach out to them. The responsibility lies with the owners instead of other persons, because that's it's the owner's responsibility to maintain their buildings. We're at Clause 23, but you were talking about Clause 25. Next, Mr. Andrew Lam. I'd like to talk about Section 22A3A. On the responsibility of a partnership, negligence or omission. I have a hypothetical question again. There are partners that don't participate in the operation of a business. They may have just invested in the company. Would that partners be held liable for neglecting the responsibility? Permanent Secretary. Section 22A is about the offenses by body corporate and partnership. If the partners neglect or omit their responsibility, the body corporate, that could be the property management company, if they don't fulfill their responsibility by neglecting or omitting their responsibility, then we will hold these directors or senior management of the property management company liable. That's the spirit of Clause 24. The spirit of this ordinance is that the owners should be held liable, whether they are body corporate or partnership. Mr. Lam. So we're not talking about intent here. I gave you a very concrete example. There are different structures to body corporate. Some partners don't participate in the management of their company. They're just investors. Under such circumstances, would they be held liable under Section 22A? Whether the prosecution is successful is another matter. Will they be charged? Permanent Secretary, Mr. Fong. Thank you. Chairman, thank you for the question. Regarding partnership, if there are a few partners in a partnership, and if the partnership does not comply with the direction or order that involves the negligence or omission on the part of the partners, we can either prosecute or charge the company or the partners. Members, our meeting was supposed to end at 6:30 p.m. We only have 2 to 3 minutes to go. Mr. Andrew Lam may have some follow questions, and Ms. Carmen Khan has indicated her wish to speak. I'll extend the meeting by no more than 15 minutes. Depending on the progress, we may have to have another meeting. I'd like to inform you of the tentative schedule. We may be able to have another meeting in early November. If we are able to complete the scrutiny by early November, then the date of resumption of the second reading debate would be (11th of November). Sorry, 20th of November. This is an assumption only. If we are able to have another meeting in early November and complete the scrutiny, then the second reading debate will resume on the 20th of November. Assuming that there is, well, the deadline for giving notice to amendment would be 11th of November.
Mr. Lam, yes, going back to the last question, what's important is the legislative intent. In reality, it is possible that a partner of a company does not take part in the operation of the company's business, and it's clearly made out in the contract or the articles of association, and yet, according to your reply, this partner may be prosecuted as well. And if you take this approach, considering that each partner has equal responsibility, then you are not considering the fact that this is a silent investor who doesn't concern himself with the running of the business. That means regardless of the intention of individual investors, you are going to go after each and every one of them. Please take note of this point. Would you like to supplement this answer to Mr. Lam's question? The spirit of the bill is to hold every owner who is non-compliant accountable. Although, like the member said, the partner may not be responsible for the running of the business, but after all, we're building this case on assumptions, and there are so many assumptions to make. Perhaps before the next meeting, we can supplement the answer in writing. Next, Ms. Carmen Can. Division 4 relates to the service of documents. We will be allowing more ways of serving the documents. And I'm looking at page 42 of the markup copy, and that we are going to exclude the other methods in clause 23 because 19W relates to the service of writ of summons. Now, can you explain how these two clauses relate to each other? In Section 2 here, it says that the writ can be left at the building. So, using the scenario of conveyance of property, does it mean that you can just leave the writ with the new owner? Please just explain the relationship between 19 and 23 first. Yes, Mr. White, please help us with 23. Thank you, Chairman. Thank you, Mr. Khan, for her questions. The understanding is correct. 23 relates to service of documents. So this part refers to the service of documents other than the service of writs of summons. Now, for writs of summons, it relates to legal proceedings to recover a debt, for example, is kind of a legal document. The service of such a document is different from the service of other documents. So that is why we have 19W, which stipulates the methods of serving the writs of summons. Ms. Khan's understanding is correct. What about the example that I just cited? Under 19W, for the payment in default under 19T, the writs of summons can be left at the building concerned. So does it mean that the writs of summons can be left at the premises now belonging to the new owner? As I understand, here it said that it should be left at the defendant's residence or place of business. If there is a new address, be it residence or place of business, that has come to the attention of the government, then the writs should be served at that new address. Right, that comes to my next question. Would it be possible, like Dr. Loy Kwok said, that there will be a chance that the matter cannot be resolved because, like 19V8 provides, that the original owner, and that is the defendant, will have to make full payment first. And until he does so, the recovery certificate will still be registered against the title in the land register. Well, Ms. Khan raised this point, and I think you can go back and think about it. If my memory serves me right, I think under such circumstances, it's said that the owner will be held liable. And that's the case even after the conveyance of the property until the payment has been recovered in full, and that this certificate will remain registered at the land against the title. But according to this subsection here, that is subsection 7, this new purchaser can be regarded as a bona fide purchaser. So this purchaser would be absolved from liability. But subsection 8 provides that the certificate will still be registered against the title until the payment has been made. And then about service of writ of summons, the writ will be left at the address last known to the government, and that's probably the property in question. So here we come to the scenario as mentioned by Dr. Lo Wai Kwok. According to subsection 7, the new purchaser will be absolved from liability. But according to 14 capital B, the new purchaser is obliged to inform the enforcement authorities of the transfer of property or transfer of interest. I think I'll stop here because under the Buildings Ordinance 14B does not exist, and the purchaser is not given the same protection. What is quite complex, I think that in their written reply they are going to tell us the procedures concerned. And Ms. Khan's point is related to the procedures. And about service of documents, we explained how documents should be served under certain circumstances. And I think you'll find details in clause 15 as well. Just now, a member raised a question about this, and then the administration gave an explanation. I think when we come to clause 25, we will be given more details about the service of documents. I think we are still discussing 23, but in fact it's clause 25, section 23, not clause 23. Well, anyway, our time is up. I think we will continue with this discussion next time. I think by then the discussion will be more meaningful. It will help members understand better. As I said in the previous sections or clauses, there are also references to service of documents as well, like 19. So I think we'll wrap up our discussion here. At the next meeting, I'd like to first discuss when this will happen. I will discuss with the administration. Hopefully, we can have another meeting in early November. And I believe another meeting will be sufficient for us to scrutinize the remaining clauses. And meanwhile, the administration should prepare a written response to matters raised at today's meeting. And please give us this reply before the next meeting so that we have time to prepare. The administration has proposed some committee stage amendments, and they have walked us through these amendments very briefly. If you have comments, please tell us at the next meeting. I suppose the administration is going to urge us to support the 2 amendments, right? Anything else from the permanent secretary? We are going to fully support the work of the Bills Committee. Thank you. AOB. Nothing under AOB. Members will be informed of the next meeting, including the date and the arrangements. That's all for today's meeting. Thank you.